Good morning, Florida. This is Juan Arias coming to you live from Fort Lauderdale, Florida. Welcome to my free webinar under 10 minutes considerations when hiring an attorney or a paralegal from the other side. Do's and don'ts. Let's get to it. When you consider the hiring a new attorney or a new paralegal that has worked in the same area of the law on the other side, meaning in law firms or companies that may have a legal department in where they were privy to confidential information of clients, you need to be very careful during the hiring process. There's no cookie cutter answer as to how conflicts of interests and potential disqualifications apply to all cases. So this is a very case-by-case analysis that you have to make every time you're considering to hire someone who has worked, on the other side of your issues. For example, if you're a plaintiff attorney, somebody that has worked on the defense side in PI cases, or I see it a lot in the insurance industry that they have their own legal departments, and when they hire from an opposing law firm, that creates issues. So again, it's all case by case. You got to screen properly these potential new hires. And the two things for you to consider, the most important part of your analysis is to understand that you have ethics requirements that you need to consider, and you also have litigation requirements. Because in litigation, when a side moves to disqualify the other, courts have used variations of the analysis to determine whether or not there's a conflict of interest and is going to be imputed against the law firm. So you have one, the ethical considerations, and two, the actual practical considerations when it comes to the litigation down the line. So what you need to strike when you are considering to hire from the other side is you got to strike a balance, understand the confidentiality rules, understand the attorney-client privilege, and of course, conflicts of interest. There are 8 rules of conflicts of interest. And by the way, I'm teaching a whole hour on conflicts of interest on September 17 at noon. This is a webinar sponsored by the Broward County Bar Association and 11 other bar associations from across the state of Florida. So September 17th, I'm going to break down all the different conflict of interest rules. But in general terms, you need to understand the conflict of interest rules. And there are 5 in particular that you need to keep in mind, and you need to fit your facts dealing with a new potential employee to those particular rules. For example, Rule 4-1.6 is confidentiality of information. Point 7 is conflict of interest current clients. So if you have an issue of a hire that has dealt on the other side with current clients, you need to look at that rule very, very closely. 4-1.8 is conflict of interest prohibited and other transactions. You need to understand that. You also need to look at point 9, which is conflict of interest with former clients. So if you're hiring somebody who at some point represented a client, a former client of yours, that's the rule you gotta look at. And of course, point 10 is the general rule on conflict of interest. So the first thing you do when you are considering hiring from the other side is you need to look at these rules and see if there are facts that fit the specific rules. Why? Because if in fact you hire somebody that may create a confidentiality issue, an attorney-client privilege type of situation, or a conflict of interest, that may be imputed to your law firm, and it may take the entire law firm out of the game, out of the representation of in that particular matter, and that's under point 10. So it is very important that you do the proper analysis before you actually hire someone. So let's look at the ethics side. As I said at the beginning, you have the ethics side considerations, and then you have the considerations down the line on litigation if somebody moves to disqualify you. On the ethics side, the rule that is relevant is 4-1.10, as I said earlier, and that is imputation of conflict of interest. In law firms, if one lawyer is prohibited from representing, then none of the lawyers in the law firm could represent. That is the black and white rule on disqualification under 4-1.10. And the rule actually makes a distinction between lawyers and non-lawyers, which is interesting because, as I'm going to discuss a few minutes in the future here, courts have really not distinguished that much between a lawyer and a non-lawyer when it has come to litigation and disqualification. They have put them at the same level because they're looking at what? Not at the capacity of service, who was serving in what capacity, but they're looking at whether or not confidential information was obtained. So it's a different angle, a completely different angle, but the rule does differentiate between an attorney and a non-attorney. The rule provides, the comments of the rule provide an explanation on how these issues of conflict of interest are sorted out. And they actually, in the comments, talk about a functional analysis. And they say it applies to determining disqualification. And the analysis analyzes two particular functions. They say, one, preserving confidentiality, and two, avoiding positions adverse to the client. So through those lenses is how the bar rule analyzes whether or not somebody is conflicted out or disqualified or is violating, the attorney-client relationship. And of course, the application of this functional analysis depends on the cases. So when I get calls from my clients all the time from across the state of Florida, as you know, I give a lot of consulting. I do consulting for many law firms across the state. I get calls all the time, and especially now that hiring is so fluid. People are moving, and people are reconnecting now under COVID, and I always get a call. Hey, what's the black and white on this? Well, there's no black and white because it all depends on the facts. I need to get into the facts to determine whether or not this functional analysis applies and disqualifies, or we have to move to the litigation case law to try to sort out the facts to things that have been already decided by the courts. So you have the rule on the ethics side, Rule 4-1.10, and you also have an ethics opinion, 86-5, that has tackled the issue of disqualification. In that particular opinion, it's very important to stress out that it allows a screening of non-lawyers. So again, it creates kind of a different treatment for non-lawyers versus lawyers. But then the opinion actually says, on the top of the opinion, and I'm going to read it, that the opinion permits screening of non-lawyer employees to avoid conflict of interest. That's great. But then he says it does not purport to address the possibility of disqualification in litigation. And it actually goes to mention several cases where different district courts have been all over the place in analyzing disqualification. So that disclaimer says a lot, because the Florida Bar is saying, yeah, we have this beautiful rule, and this is the functionality analysis. Functional analysis is all beautiful, but when you move to litigation, it's just another game, and you need to be aware of that. If there's something that you need to keep in your mind, is that whether or not you are dealing with hiring a lawyer or a non-lawyer from the other side, that the Florida bar rule is there and the opinion, but there is case law that it's really all over the place when it comes to applying the analysis of whether or not there is a disqualification because there's a violation of confidentiality. So again, litigation side, what I can summarize for you under 10 minutes based on all the different approaches and the case law out there on disqualification is that one, Florida districts differ on the approach to determine disqualification. You're going to see case law from the 2nd district, the 3rd district, the 4th. Very, very convoluted. And again, case by case, you need to look at your jurisdiction. So district courts are not in line. Two, the second thing you can get from reviewing all this case law is that in litigation, attorneys and paralegals are mostly treated the same. The analysis that, because remember, the rules of ethics applies what to the attorneys, and through the attorneys they apply to the non-attorneys, and when it comes to analyzing confidentiality and the bond between the client and the lawyer, they just look at the facts. They don't care, again, which position these people are in. Is whether or not they really obtain and confidential information that could, make a difference and could affect that client that was left behind, and that now the confidentiality and the protection of the information is at stake. So the third thing is that some courts, like in the 4th DCA, apply a prima facie burden on the hiring firm. It is the hiring firm, the one that has to really show that they did not obtain any confidential info. So it's not the complaining side, because you would assume that is the other side, the non-hiring side, the one that lost the client side fighting, but the burden shifts, and it is up to you, the hiring firm, to actually convince the court. So you're going to see that. Also in litigation, you're going to see that courts favor disqualification in closed cases, and that's the case in the 4th DCA where we are located, meaning my law firm. So very case specific. Again, we got to look at the particular facts. Check out the Culisis case. That is in my jurisdiction in the 4th DCA, 730 Southern 2nd 289. It also gives a little glimpse of other districts, how they have analyzed disqualification, and keep in mind prior to hiring from the other side that all these considerations need to be at the forefront. I obviously, as the rule says, you should always screen the potential new hires and make sure that you properly identify whether or not there are conflicts based on the list of cases they have worked in the past. You got to do your homework. I do that a lot for some of my larger clients, both in the law firm and in the industries. Make sure that I become the barrier to make sure that whatever I get, I can push back and say, no, we have potential issues without compromising my clients, the employers. So under 10 minutes, do and don'ts on considerations on hiring attorneys from the other side. As you know, I represent on Florida bar complaints. I represent law students. I represent nurses and healthcare practitioners with their boards. I'm here to assist you in anything you need. You can call me. You can contact me through Facebook. And remember, on September 17th, conflicts of interest and waivers of conflict, I'm going to dive into the different rules and considerations. Good luck to you all. Be safe, and thank you for your time. Bye-bye.